There's a knock at your door. Early morning. You look through the peephole and see men in tactical vests. They say they're from ICE. Your heart is pounding. Your family is inside. And in the next 30 seconds, one wrong move, one wrong word could change everything. Every single day across America, people open their doors and hand federal agents the one thing no warrant ever gave them: permission. Not because the law requires it, because they didn't know what to say. Because nobody told them that the Fourth Amendment draws a firm line at the entrance to your home, and that line only moves if you move it. I've spent years studying immigration enforcement law, analyzing hundreds of documented ICE encounters, and reviewing landmark Supreme Court decisions that established exactly where your rights begin and end at that door.
And I've identified 4 critical mistakes people make the moment ICE knocks up, and the exact words that protect you from every single one of them. This is educational content only. For your specific situation, always consult a qualified immigration attorney in your jurisdiction. But what I'm about to share could be the most important legal knowledge you ever hear before that knock comes. Let's break down the 4 mistakes and the 4 exact phrases that protect your home. Mistake 1, opening the door. The mistake. ICE agents knock. They announce themselves. Most people, out of reflex, out of politeness, out of fear, open the door. The moment that door swings open, the entire legal landscape shifts against you. The scenario. It's 6:30 in the morning. The knock is loud and urgent. You hear, "ICE, open up." You open the door. An agent steps slightly forward. He's now in your doorway. He says he's looking for someone. You say, "That person doesn't live here anymore." He says, "Mind if I take a quick look around?" You hesitate. You already opened the door. You already started talking. It feels too late to say no. So, you step aside. Congratulations, you just consented to a warrantless search of your home. Why people do it. People open the door because the knock feels like a command. It sounds official. It sounds like non-compliance is illegal. But it isn't. Opening a door is not required by law. Speaking through a door, or not speaking at all, is entirely within your rights. Legal reality. In Payton v. New York, 445 U.S. 573, decided by the Supreme Court in 1980, the court established one of the most important Fourth Amendment principles in American history. The court ruled that the Fourth Amendment draws a firm line at the entrance to the house. Absent exigent circumstances, that threshold may not reasonably be crossed without a warrant. The home is the place where constitutional protections are at their strongest. The government cannot simply walk in. And critically, this protection applies to everyone inside the United States, regardless of immigration status. Evidence problem. If you open the door, courts may treat what happens next as consensual. Agents can observe the interior in plain view. Anything visible from that open door can be used. Your gesture of opening it becomes the foothold they needed. Officer psychology. ICE agents are trained in tactics designed to create the appearance of authority beyond their actual legal power. A loud early morning knock is not an accident. It is a deliberate psychological strategy to catch you disoriented before you have time to think. The correct move? Here's phrase 1. Do not open the door. Instead, speak through it or through a window. I do not consent to your entry. Say it clearly, say it calmly. You are not being rude. You are invoking your Fourth Amendment right, which the Supreme Court ruled in Payton is at its peak protection inside a private home. If agents have a valid judicial warrant, they will tell you, and you can ask them to slide it under the door to verify. If they do not have one, and most of the time they don't, your closed door is your legal shield. Bottom line, never open your door to ICE without first establishing whether they have a judicial warrant. Until that question is answered, keep the door closed and say, I do not consent to your entry. Mistake 2, confusing an ICE warrant for a judicial warrant. The mistake. An agent says, "We have a warrant." Most people hear that word, warrant, and assume it means the door must be opened. They step aside. But there are 2 completely different documents that use that word, and only one of them legally requires you to let anyone inside your home. The scenario. You stay behind the closed door. The agent says, "We have a warrant for someone at this address." He holds up a document. It looks official. It has a seal. It has a name. You open the door because it looks real and it looks legal. What you didn't know is that document was Form I-205, an administrative warrant signed by an ICE officer, not a judge. That piece of paper, by itself, does not legally authorize entry into your home. Why people do it. The word warrant carries enormous authority. People do not know that two entirely different documents carry that label. One is issued by a federal judge under the Fourth Amendment. The other is an internal immigration enforcement form signed by agency officials. The difference is everything. Legal reality. The distinction between these two documents is firmly established in American law. A judicial warrant, also called a criminal warrant, is issued by a neutral federal judge or magistrate based on a finding of probable cause. Under Payton v. New York, this is the document that authorizes law enforcement to enter a home. An ICE administrative warrant, typically Form I-205 or Form I-200, is signed internally by an immigration official. It is not reviewed by a judge. Multiple federal courts have addressed this directly. A California federal district court ruled in 2024 that ICE administrative warrants do not authorize ICE officers to enter homes to make an arrest. In January 2025, a Minnesota federal district court also held that a home entry based solely on an administrative warrant violated the Fourth Amendment. The National Immigration Law Center's own guidance states clearly, an immigration warrant is not the same as a judicial warrant and does not authorize a search of non-public areas. Evidence problem. If you open the door based on an administrative warrant alone, you may have just consented to an entry that had no legal authority behind it. Courts in multiple circuits have found such entries unconstitutional. But if you already opened the door and allowed entry, that consent issue complicates any later legal challenge. Officer psychology. Agents know that most people will not know the difference between a judicial warrant and an administrative warrant. Presenting a document with official letterhead at 6 a.m. to a frightened resident is designed to create the impression of legal authority the document may not actually carry. The correct move. Here is phrase 2. Ask them to slide the document under the door or hold it up to a window. Then ask this specific question. Is this warrant signed by a federal judge? A valid judicial warrant, the kind that actually authorizes home entry, will name a federal judge or magistrate and bear a court seal. If the document is only signed by an ICE official, it is an administrative warrant. At that point, you are within your legal rights to say, this does not appear to be a judicial warrant. I do not consent to entry. Bottom line. Never assume a warrant means you must open the door. Always ask whether it is signed by a federal judge. The answer to that one question determines whether a lawful right to enter exists. Mistake 3. Answering questions at the door. The mistake. You've kept the door closed. The agent asks, does Maria Gonzalez live here? You say, she moved out. The agent asks, when did she leave? Do you know where she went? You answer again. You're trying to be helpful, but everything you're saying is being recorded. You've just confirmed the person was at this address, given a timeline, and potentially revealed information about a third party's whereabouts. Why people do it. People believe that answering questions honestly makes them look innocent and uninvolved. They fear that silence looks suspicious. But your Fifth Amendment right to remain silent exists precisely because the law recognizes that statements made under pressure, without an attorney, can be taken out of context, misremembered, or used in ways you never anticipated. Legal reality. The Fifth Amendment to the United States Constitution states that no person shall be compelled in any criminal case to be a witness against himself. In Salinas v. Texas, 570 U.S. 178, decided by the Supreme Court in 2013, the court clarified that to receive Fifth Amendment protection during voluntary questioning, a person must explicitly invoke it. Silence alone, without invoking the right, may not be fully protected. That means you need to say the words. Additionally, the Fourth Amendment protections that apply to you in your home also extend to those inside it. You have no obligation to answer questions about other residents. Evidence problem. Every word you speak at that door is being recorded on body cameras and potentially on audio devices. Statements confirming a person's connection to an address, their habits, their schedule, or their whereabouts can be used in enforcement operations. What feels like friendly cooperation is legally a voluntary statement that can be used as evidence. Door. They are calm, conversational, and designed to feel like normal dialogue. The goal is to gather the probable cause through your words that they could not otherwise establish. The correct move. Here is phrase 3. Do not answer substantive questions about other people, residents, or your household. Instead, state clearly and calmly, I am exercising my right to remain silent. I have nothing to say without an attorney. Repeat it if they continue. You do not need to explain yourself. You do not need to justify your silence. The right to remain silent is a constitutional right, and invoking it explicitly, as Salinas requires, protects that silence from being used against you or interpreted as evidence of wrongdoing. Mistake 4. Not documenting what is happening. The mistake. The encounter ends. The agents leave. You are relieved. But you did not write down badge numbers. You did not record what was said. You did not note how long agents remained at your door. You did not check whether any paperwork was left behind. Weeks later, you need to challenge what happened, and you have no evidence. The scenario. ICE agents came to your door for 20 minutes. They made statements about a warrant. They asked questions. One agent attempted to put his foot in the doorway. You told them you didn't consent. They eventually left. Later, an attorney asks you for the name of the lead agent, the document number on any paperwork presented, and what time the encounter began and ended. You have none of it. Your legal challenge is severely weakened. Why people do it? Documentation is the last thing on anyone's mind during a high-stress enforcement encounter. Adrenaline takes over. The focus is entirely on surviving the moment. But documentation is what transforms a civil rights violation into a case that can be challenged in court. Legal reality. You have the right to observe and document law enforcement activity from your own home. You do not need to step outside to record. Recording from inside your home or through a window is protected. If ICE agents entered without a judicial warrant and without your consent,
The legal remedy, suppression of evidence, and potential civil rights claims depends almost entirely on documented proof of what occurred. Federal district courts in California and Minnesota have both ruled against warrantless ICE home entries in recent cases. But those rulings were only possible because the encounters were documented well enough to bring before a court. Additionally, under the Fourth Amendment's exclusionary rule, established in Mapp v. Ohio, 367 U.S. 643, 1961, evidence obtained through an unlawful search cannot be used in court. But establishing the search was unlawful requires documentation. Evidence problem. Without documentation, it is your word against the agency's. Body camera footage from agents may be the only record of what happened. That footage is controlled by the agency. Your own contemporaneous record, written, photographed, or recorded, is the independent evidence your attorney needs. Officer psychology. Agents who exceed their authority understand that undocumented encounters are nearly impossible to challenge. The absence of records is not an accident in enforcement operations. It is an advantage. Bottom line, always document. Always say, I am documenting this encounter for my legal records. That record is the foundation of every legal protection that comes after. Here's the truth about ICE encounters at your home. The Fourth Amendment was written because the founders of this country had lived under British rule, where agents of the Crown could enter any home at will under what were called writs of assistance, general warrants that required no specific justification and no judicial oversight. The entire purpose of the Fourth Amendment was to make certain that could never happen on American soil. The Supreme Court in Payton v. New York reaffirmed that purpose in 1980, drawing a firm constitutional line at the entrance to the home. Every person inside the United States, citizen, permanent resident, visa holder, or undocumented, is protected by that line. Knowing where it stands and what to say to enforce it is not obstruction. It is the exercise of rights that the Constitution guarantees. Here are the 4 phrases one more time. Write them down. Put them somewhere you will find them. Phrase 1. I do not consent to your entry. Use this immediately. Do not open the door until you know what you are dealing with. Phrase 2. Is this warrant signed by a federal judge? Use this when agents claim to have a warrant. An ICE administrative form is not the same thing. Phrase 3. I am exercising my right to remain silent. I have nothing to say without an attorney. Use this when agents ask questions. Invoke it explicitly. Phrase 4. I am documenting this encounter for my legal records. Use this during the encounter. Your documentation is your legal foundation. 4 phrases, a closed door, and
knowledge of where the constitutional line actually stands. Establish a relationship with a qualified immigration attorney before any encounter happens. Know your local legal aid organizations. Have a number you can call. Because the best time to know your rights is before you ever need them. This is educational content only, not legal advice. Laws vary by jurisdiction and your specific circumstances matter. Always consult a licensed attorney for guidance on your individual situation.
If this helped you understand what the Fourth Amendment actually protects inside your home, share it with your family, your neighbors, and everyone you know who could need it. Because these rights only protect you if you know they exist. The people who come through this with their rights intact are not the ones who panicked. They are the ones who knew exactly what to say, exactly when to say it, and exactly when to stop talking. This is educational content only, not legal advice. Consult a qualified attorney in your jurisdiction for guidance specific to your situation.